Start. Civil Appeal Number 159 of 1953, appeal under Article 132 (1) of the Constitution of India from the judgment and order dated 4th December 1952 of the High Court of Judicature at Patna in miscellaneous judicial case number 241 of 1952. N. C. Chatterjee and B. B. Vishwas for the appellant company. The High Court was wrong in holding that there was no warrant for issuing a writ under Article 226 of the Constitution on the facts of the case, although no actual assessment was made by the sales tax authorities. The issue of notice by them constituted a sufficient threat which the High Court had jurisdiction to quash by means of a right under Article 226 of the Constitution. Commissioners for the general purposes of the income tax for General Commissioner, which is in Part 12 of the Constitution, is meant to implement the supremacy of Parliament with regard to interstate trade or commerce. That article puts an embargo on the power of the state legislature to levy any tax with respect to interstate trade or commerce only when the embargo is lifted by appropriate parliamentary legislation. That the state legislature can levy any tax on sales or purchases in the course of interstate trade or commerce. Article 286 puts a fetter on the state legislatures, and the explanation to Article 286 (1)(a) does not confer any power on any state legislature to levy any tax. The explanation is meant to explain only Clause 1 of Article 286, that is, what is an outside sales or purchase. It does not remove fetter, and it does not convert any interstate sale or purchase into an intrastate transaction. Judgment of Bose in the State of Bombay versus the United Motors India Limited (1953) SCR, and that of Das J in the State of construction of the explanation by the learned judges of the High Court is not correct. They were wrong in assuming that if Article 286 (2) is construed in a full and unqualified sense, the explanation to Article 286 (1)(a) would become nugatory and of no effect. They also erred in holding that the explanation expressly confers legislative power, and that the explanation is in the nature of an exception which excludes a particular class from a larger class. The High Court erred in holding that the explanation created a nexus for conferring jurisdiction on the state legislature. Test of territorial nexus is no longer applicable after the coming into force of the Constitution. On a proper reading of all the sections of the Bihar Sales Tax Act 1947, the idea seems to be that the intention was only to tax the dealers within the state of Bihar, as come of the provision of the Act would be incapable of enforcement outside the state. Consequently, the appellant, which has no office or agent within the state, could not be taxed. Legislature has no power to authorize imposition of tax on outside dealers. The legislative competence of a state legislature is derived from Article 246 read with the list. Under Article 245 in bracket 2, Parliament is given power to enact legislation with respect to extraterritorial operations. Stop.